You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
Ross, it's good to talk to you. I missed you.
I missed you too, man.
That may be why subconsciously I subconsciously took a wrong turn. I'm actually at your driveway right now, at your house.
At my house?
And you don't even know that I know where you live.
I was going to say, how'd you know where I live? We've never... Ooh, what?
I've got connections.
He knows the lawyer, probably. He knows my lawyer.
But I actually I'm literally in a parking lot right now.
Look at that. It's amazing. This sounds quality.
Go for it.
It actually sounds better than the studio. All right, well, let's see here.
No, I prefer to be out.
You want to just come in, or you want to do we can do the first break from the luxury vehicle that you currently reside in?
Give me 30 seconds.
Okay.
No, it is nice. It's very pleasant. The air's at 68, but I'll come on in.
Okay, come on in. All right. You'll be joining us on the guest mic in mere moments. First segment, we're talking about a couple of the national stories. One we had this week where a guy felt betrayed by Apple. He's suing for $6 million because he was deleting text from his hookers, but they got posted on his home computer. Stupid cloud. So that is a real deal. And a very interesting one, too. It was the end of a ski vacation in March of 2022 when a guy and his daughter were on the Paradise Express lift at Crested Butte. The chairs spun around, and she couldn't settle into her seat. He grabbed her. The chair kept climbing up the lift terminal. He screamed for them to stop, and people didn't stop. She tried to hold on. He tried to hold on. She fell from 30 feet into hard-packed snow, sustained a shattered C7 vertebrae, a bruised heart, lacerated her liver, injured her lungs. That's a fall. That's a 3-story fall, by the way. And imagine the terror of the dad holding on to his 16-year-old daughter. Oh, don't let go. It's like, I'm sure just every father's nightmare. So she fell very, very much injured, and Crested Butte was trying to use the legality of the lift ticket, which, of course, if you've ever skied or snowboard or whatever on there, says not responsible for injuries. This is a sport that could have injuries. And, well, that didn't stick. They're going to be allowed to sue for that injury. And we talked of liability waivers several times over, McDivitt, and it seems like they were fairly ironclad. What makes this one different, you think?
Well, some of what's been done here with the legislature in Colorado is to carve out protections for ski resorts, ski resort operators, too.
Because you want to be accommodating. They bring a lot of money this year.
That's right.
Right?
People get... That's right. People get... And skiing is such a huge part of our economy in Colorado. Right? So, got these protections in place for the ski resort operators. And the intent there is to make sure that people can go skiing, and that these resort operators and the people who are running the mountains who are getting the leases from federal government are...
Because you could imagine the extent, if it was a kind of a Wild West aspect, the amount of lawsuits that they would have to continually try
constantly. People are getting...
I got cold, I got frozen, I got some frostbite because the wind was so... Hit a tree, got hit by a Texan.
Yeah. Oh, and you get hit by Texans all the time.
Yeah, so there's all kinds of various things. So this one just being so extreme, they decided this exceeds that level of...
Well, there's a point where, I was walking when you were explaining some of the details about what happened with the lift. The young woman's on the lift and the lift malfunctions. There are other elements to this that are beyond the scope of that immunity protection that they have. So, the idea is to keep people from being able to protect their operators so they're not getting sued every time somebody hits a tree or falls down or they get hit by another skier. You can sue the other skier. If somebody was negligent on the slope and you're hurt because of that, you can sue that person. But skiing is inherently dangerous. However, when you get on the ski lift, you have certain expectations that it's been well maintained and that they continue to train people on how to conduct the whole lift operation safely so that you're not hurt from that.
Interesting.
So, that's a carve out from that.
Would that have made a big difference in allowing this lawsuit to go through or not if, in fact, she was just hurt on the slope as opposed to on the lift?
Makes all the difference.
Really?
Yep. And
wow.
it does not mean that every injury on a lift is going to be...
Because there's no negligence if it's, she was skiing out of control or she did this. And, that's very interesting, just like time and a place. But it makes sense because you are expected to know those work well. Those get you from point A to point B safely.
That's
because
right.
It is scary. I mean, I don't like heights very much. And so there's a few times that you got this huge board strapped to your leg. It's like, I'm way up here. And then we had similar things where a lady was locked in overnight and she's still trying to get her lawsuit greenlit because they just shut the lift off. Good night, everybody.
They didn't even know she was on there.
No.
Yeah.
I think it was one of those gondola things. So
that's
she wasn't
where
exposed.
I always wear glow-in-the-dark underwear. Just so if I'm ever exposed in a situation like this, I can peel down to my base layer and I am just glowing all night long.
I can squeal and scream like the best of them. I have a scream on me. I can't demonstrate it right now, but I got a scream on me. All right, so that's interesting. We'll see where that goes. And then the sad thing about this is over 2 years it took just to say, yeah, you can sue.
That's what happens because
these daughter that's all beat up and now 18 years old, right. Obviously with a lot of medical conditions. So
these cases they crawl through the legal system. Many of them. That's right. We've got different levels of appeal for these too.
All right, we'll get to some local stuff too from our emails, and you can always send us a question for the Law Frog anytime, even if it's we're right now going to be the furthest away from our next visit, but you can also drop one there if you'd like. It's under the contact page. It drops down, says Law Frog. You can do that. It's McDivittlaw.com if you want to keep it personal and contact with pros over there or settle a score. Just hit 4-719-444-4444.
Keep telling fours.
All right, so before we get to that, and anything you want to call, 633-KILO. We can probably field someone on the air. We got plenty of time here. The other story came up earlier this week, and I didn't get this to you, so I'm not going to hold your face to the fire, but it seems ridiculous, but then I read it and it's like, that's probably going to work out for a guy. So, dude is suing Apple after his wife found a bunch of text messages that he sent to his hooker friends. Mm-hmm. He turned to prostitutes years ago because of tough times in the marriage or whatever. So he texted them using the iPhone messaging app iMessage, but he was always very careful to delete the message so his wife wouldn't see. Unfortunately, dummy didn't realize this cloud thing, so all these would be posted on their iMac desktop at their home.
Yep.
She stumbles across it. Boom. He's gone. She's probably going to reap millions in a lawsuit, and now he's suing for $6.3 million, suing Apple because they should have to cover what he loses in the divorce and all the legal bills. He said he could have, if it wasn't found out this way, he could have worked his way through it, but Apple failed him by reposting on his iMac. Does this even have a chance? I mean, read it like this. Guy cheats on wife with hookers, gets busted, gets divorced, and gets $6 million. That sounds, unfortunately, real.
Well, I don't know. I would have a hard... If this guy succeeds with this lawsuit, I will be personally very frustrated because I don't like this kind of a claim. And partly because I know this iMessage technology fairly well, having been in a situation where, I know people who, when they text, and then those texts get on the family desktop, and you're sitting there thinking...
Do you have any specific stories?
No, I'm not going to get into that. I'm not going to get into that. But I'll tell you this, Ross. They explain how this technology works. Yeah. And so if you adopt a technology as an end user, and you use a cell phone and you have text messages, keep in mind, there's a reason something like WhatsApp is attractive to people because of its special end-to-end encryption, and you just can't... It's like not hackable, basically. And it doesn't have those other kind of redundant safety features so that the messages don't get lost. And it's iMessage, it goes to the cloud, it's accessible on all your Apple devices. That's why people migrate to an Apple environment anyway. So these are things
your greasy burner phone.
This stuff is, a quick Google search, like what happens, how do I do iMessage? What happens to my messages? The information's out there. I think Apple probably does a good job of explaining how their technology works. And for him to then be able to say, listen, I had no idea that my technology could do this, and therefore, because I'm carrying on this illicit affair with hookers, and I got busted, now Apple's on the hook for that.
All I wanted to do was cheat on my wife with hookers, and Apple ruined it.
Damn you, Tim Cook.
And my thing was, I assume in that long list of the terms of agreement, I'm sure it's in there. I've never read it because it's, again, long, and very boring. But I bet in there is some kind of explanation as to how it works. And ignorance is, you can't hide from the law just being ignorant,
defense.
Right?
No, I mean...
It's like a guy who's like, I didn't know it was 75 miles an hour. I thought it was 90.
That's right. That doesn't fly. Work. No, it doesn't. And those
chance of success on a 0 to 100%.
I don't like 5%.
Okay.
Yeah.
Minimal.
I think it's very minimal.
Because at first I was like, there's no way this can work. Then the more I thought about it, I was like, that sounds about right.
Here's what's going to happen.
That happens to people like this. I cheated my wife and I got $6 million. Thanks, America.
Okay, did he file the lawsuit already?
I don't know if it's actually filed or not.
I mean, he's hired a lawyer. There's a lawyer out there getting some PR from this. And that's that lawyer's value from this case. I think Apple would win on, kind of what they call summary judgment, or they get these early stage motions, get it kicked out of court. I just don't see that going anywhere. But you know what? I have been wrong.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
They selected me for what was essentially a one-day municipal dog bite violation.
Cool.
This is Denver County. And both parties stipulated, it's almost worth explaining what happened because it's comical in the sense that what I would call a waste of judicial resources. It's unfortunate because these people's lives were impacted for a very significant amount of time, several days, plus the woman who was being charged. You basically had a situation where there is a apartment complex somewhere in Denver, and a woman's boyfriend was walking the dogs, took them to a tennis court, and the dogs were off leash on the tennis court, and then the dogs broke through the door because it wasn't securely latched, and then attacked another woman's dog. Well, one dog attacked another woman's dog. So it was dog-on-dog violence.
Dog-on-dog violence. My least favorite kind of violence, by the way. Yeah,
I know. And the small dog was ultimately okay. I mean, had to have
good
stitches, and then they charged the owner of the dog with several municipal violations.
Yeah, leash and stuff like that.
Not having a leash and a dog bite, like a bite. And so in opening statements, even the defense attorney said, we stipulate that the dog was off leash. We stipulate that the dog did bite this other dog, but we don't think that she's guilty of fill in the blank, or because of. And even and so after it was over, it took us, 20 minutes maybe. And most of that was just because we all had to go to the bathroom. And it dragged on to the second day too.
What?
So we didn't get out until the afternoon of the second day. And even talked to the judge. We said, look, Judge, we don't think that because of what this woman did, she should be, you don't send her to prison for this. But you brought these charges and they met all of the elements. And what are we supposed to do?
Why are we even here?
Yeah, I know.
Wow. See, that's kind of a sad portrait of ours. I mean, but you got to have those checks and balances. And stuff like this that's frivolous also leads to some big stuff.
And then there was a big to-do about one of the jury instructions. And I probably am one of the reasons there was a to-do because then I started arguing after the fact because they wanted to talk to the jurors about why we made our decision. And I got into it with the defense attorney about the jury instruction. I said, look, what did you want us to do? You stipulated that this happened. All of these elements were met. That's it. We have to find this person's guilty.
Innocent because she's a very nice lady.
Well, you can do that. It's called jury nullification. But we didn't do that. Yeah.
Pretty funny, not ha-ha
funny. But Ross, I was thinking of you that whole time. I was thinking I could be in the studio with Ross, but instead I'm here.
It's funny because I was thinking of you. I was like, free sack lunch.
It wasn't free. We got it.
You don't get free sandwiches?
We didn't even get free parking.
Dude, our system is so broke.
We had to pay for parking, had to pay for the vending machine.
Wow. Attica.
You know what?
Great news. We had, and I'm sure most have heard, one of our call-ins, a guy had some trouble with a previous car accident. The folks that were involved were trying to get more money. Say, hey, we're not done with you yet. You owe us another, like $5,000 out of nowhere. And it was already settled, so he told him to go look at his settlement, make sure there's something signed. He found that document. It was signed, free and clear.
Just run it up to their window and shove it in their face.
Good. And then we had another one, too, that concluded just a couple of days after that. There was a guy who bought a van from a dealership, and driving home, the check engine light came on, and it was a catalytic converter. And I mentioned that, something they just reset, and it's probably been an ongoing problem. And they brought to the fact, well, you don't need it here in the Springs because we don't have admissions here, so it's fine. And it's like, well, we talked about, if the guy moves to Denver and stuff like that,
right,
needs to get admissions, it should be fixed. And they came out, we said, just go talk to him, be reasonable. And that came to the conclusion, basically, he bought one online, a catalytic converter, and then they installed it.
Okay. Met in the middle.
Look at that.
Got it done.
And that's like we've had some neighbor disputes that could be fixed. It's very similar, just a little bit of compromise. Just a little bit. And that goes for all these problems in the world, a little bit of compromise. No one wants to compromise because everyone's like, I'm 100% right all the time.
Yeah.
So good. And he says it's very, very professionally done. So
I think that's great. I think if more people just communicate with each other, a lot of these could be resolved.
Big time. All right, let's get to a couple of our questions here today. Let's start with the renters here. We got 2 stories. Do you want to do the renter for 9 years or the folks that still don't have working toilets?
Oh, gosh. Let's do the toilets.
Let's do the crappy one first. So this is from Rhonda. Signed a lease for home in December of 2023. Didn't move until mid-December because the toilets weren't working. Still don't have working toilets. And that's more than a year now. Landlord won't respond to our messages or anything. Last plumber that was sent say there's a busted pipe underground. Landlord won't respond to the plumbers either. They have 2 kids and a smelly home with toilets full of gross poo-poo and pee-pee. Thanks for being so polite, Rhonda. By the way, anytime I can say poo-poo and pee-pee, that's a win for this guy.
Whiz.
So, man, if you can't get home, can you just stop paying rent? What happens to you if you just stop paying rent?
They may be in that. They may have reached that point, and they may have reached it a while ago where if you follow the statutory guidelines, you can get away with that. It's just moving out, basically. But now, keep in mind, again, factually, I'm just going to assume that, and it's hard to assume that they've been living there since December.
A year and 6 months?
Well, no, it says December 2023.
So just 7 months, 6, 7 months. All right.
So let's just assume they've been 7 months.
My math is horrible. I went to a public school here in Colorado. Horrible. I'm horrible.
Do not say the name.
I will not.
You've said it before.
I can't say that. I don't even know how to spell.
That's all right. So 7 months they've been living there. And are we to assume that the toilets have never actually flushed and then feces has been collecting for 7 months? I have a hard time believing that. So I think what they're trying to say is maybe it backs up periodically.
Does it fully evacuate?
I don't know. And that's the problem with being able to answer.
It smells, it's not exactly functioning.
Sure. And if you get to a point where you don't have working plumbing, though, there is a statute in Colorado that says that becomes an uninhabitable premises. And so there are guidelines that you can follow to basically get out from underneath your lease. Now, to do this, you have to follow the list of to-dos, basically.
All right. And one of those is, that's the most important part. You can easily, I've just walked out, I burned the place down and ran away. It's like, all right, now you're in big trouble.
Yeah,
and there's other avenues that you might go down that'll lead to big trouble. So this is someone I'm having trouble. Where do I start without compromising my contract side of things?
Right. Under Colorado Revised Statute 38-12-507, Tenants Remedies, subsection 1, if there is a breach of the warranty of habitability as set forth in section 38-12-5032, subsection A, upon no less than 10 and no more than 30 days written notice to the landlord specifying the condition alleged to breach the warranty of habitability, given the landlord 5 business days from the receipt of the written notice to remedy the breach, a tenant may terminate the rental agreement by surrendering possession of the dwelling unit. That means you would just walk out.
Nice. That's about you were a little fast, but a 10-day turnaround. I'm kind of
joking. Yeah, I mean, I'm not joking about the content, but I'm joking about the way that I'm reading it out.
Yeah.
But so you've got to give them notice that, hey, look, this isn't. I can't live here. And here are the reasons why.
If he's ducking them though, as far as phone calls, how do you just do a registered?
Yes.
Mail, and then if he doesn't sign for it, but it shows it went to his house.
That's fine.
Or what?
Yeah, and you can. And I believe you can even do it by email. And you can explain why, and then basically, the landlord then has some time to remedy the breach, that kind of thing. But there's a little bit of back and forth here because you've got to give the landlord written notice. So I think a telephone call is not going to cut it. You got to give him written notice.
And that's why he's ducking the telephone calls too. Yeah. Like, as long as I steer clear of this mess, that's tomorrow me.
Mm-hmm. I don't have to worry about that.
Deal with it. That's tomorrow me's problem.
It's not today me problem.
Yeah.
Today me's going to the beach.
So start there with the letter.
Start with the written letter and follow. So
and that'll either jump him into gear, or you won't hear anything, and you can literally just pack up all your crap and walk away. But then what about your refunds for your deposit and stuff?
That's what's so hard about this for people is because you pay the security deposit, the damage deposit. You've already invested money in this. There's a cost to moving. What you really want is the guy to just fix the toilets.
Fix your crap, sir.
And maybe there's a plumbing issue. I dealt with this with my new old home. So I bought this old home, and it was new to me. And then we got in there, and within 4 days, the toilet. It wasn't just the toilets weren't overflowing.
You had to run with this place.
It was the drains. The basement drains with a lot of stuff was coming up. So I went in there and we scoped it again. We realized, look, you just have to replace the whole sewer main, and that was a chore. So, yeah, it's an expensive. You're going to own a home and you're going to rent it to people and you're going to charge money for them. They're living there with their kids. You owe it. You have a legal obligation to make sure it's safe. And it sounds like this is falling below that. So, look, you can, renter, you can even go online and find out the actual statute you need to follow. It'll explain the steps you need to do. You don't have to hire a lawyer to help you out. That's going to cost money. Because really what you're trying to do is either fix the situation or stop having to pay rent. Right? But if you stop paying rent, you got to leave. Then you have to, they say, surrender the premises. That means you got to give it back. So you can't just stay there and not pay.
And then traveling back to the end of November, maybe you should make sure the toilets work before you sign a lease on a place. I mean, I'm not being your dad, but maybe, even if they say, well, the toilets aren't working right now, but they will be. It's like, all right, well, here's the thing. It says these toilets are not working as of December 1, but they will be. Sign this, sir.
Right. That's great.
Sign this, sir.
Ross, you are the
Getting
captain
sharp, buddy.
of common sense.
Sharp. All right, and then I hope this is an easy one for Citizen Jared. Live in a rental. I've lived here for 9 years. That's like a renter's dream. 9 years throwing you money.
It's a landlord's dream.
I mean, sorry. Yeah, it's like, here you go, 9 years, I don't have to do anything. What a great side hustle. So moving out, and the landlord is trying to make us pay for new carpet, trying to make us paint the entire interior, refinish the real hardwood floors, and replace a now 22-year-old deck. All of these are truly just normal wear and tear for living in a home for 9 years. So I want to know what my rights are as a tenant for what I believe the landlord should pay for, because it's just stuff that's wear and tear, and it's their home. Landlord's in charge of maintenance as far as I know, right?
Yeah, there are two different categories basically when you're looking at the damage. I say so. I don't want to use damage because that is one of the categories, but deterioration in the condition of a property. One of them would be what they call normal wear and tear, and then the other on the other side of it, it's damage. And so the tenant is responsible for the damage done to the property. So, for example, hardwood floors, scratched, gouged, warped, water damage.
Then who is the judge in regards to determining what is natural wear and tear and what is actual damage? Who's the one who determines that?
That's a good question. And it's not one I've ever been presented with because I don't really do a lot of this. So I want to be careful how I answer that. I mean, I think the landlord needs to come in and assess this, have a reasonable conversation. What's going to happen is the landlord is going to do one of two things. They're going to keep the security deposit, say, well, I've determined unilaterally that is damage. That's not normal wear and tear. If they want them to then affirmatively, if they want the tenant to then pay additional money to then correct these things, like put on a new deck, they're going to have somebody come out and evaluate, because the tenant, our renter here is going to say, I'm not paying for that. That's normal wear and tear. Somebody's got to adjudicate this.
Right.
So and I don't know if there is a short of small claims court, a place where you can mediate some of these disputes. I mean, you can go to a private mediator and try to do some of this.
It seems like, because I've been in the situation once before, and I think the landlord was just pushing us to just throw up our hands eventually, because it's like, all right, do you want your $800 back, or do you want to paint this and do this and do that and fight me for it? It's like, I don't know, just like, screw you, we're gone.
Yeah. And so I don't know what is, let's put this on the hook here. Has our renter been paying a new security deposit every year? And if that's the case, let's just say it's $1,000. So now we've got a $9,000 fund here for damage that can be refunded, and that's not insignificant. So tenant wants that money back. Landlord may be saying, I'm going to keep all of it because these are, and here's why I want to keep all of it. These are all the problems. By the way, I'm not going to fix any of them, but I want the $9,000. So where is that in escrow, or is, because as they say, possession's 9/10 of the law, right? So if the tenant hasn't paid yet for these and is willing to forfeit the security deposit, it's really up to the landlord to prove that these are damages, that they're caused by the tenant, and then the tenant's then responsible, and then he's going to have to basically sue the guy for the
and more
money.
than likely it is, it's just $800 to $1,000, $1,200. So you're like, oh, it's going to cost more than that to get me a lawyer.
Well, that's the thing.
So you get stuck in this financial conundrum, It's like, well,
and
I'm wronged, but I don't want to waste money, and I'm going to just cut my losses.
Yeah, and there may be certain things that dictate how frequently a landlord has to replace carpet, for example.
Right.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
I'm trying not to dive too deep in it to lose anyone. Basically, Zach trying to do the right thing. October last year, he requested to modify his child support payment, paying for 2 kids. One was married now and 24 this year. The other's 19 and now moved out of the house. So technically, they're both emancipated. So ultimately, he was paying for shared 50-50 parenting, even though the youngest lived with him full-time since January of 2021. So went to the courts. The judge sided with him and then wanted to do an order to have his ex-wife start paying him what he was paying her, plus a newly dotted $10 a month added to the stipend. So, and he's like, nope, I don't want anything. I just want to wash this clear and let's start over. We're good. And now it's spiraled. His wages is being garnished. They didn't go off the final judge's basically orders. They're pulling from other stuff from a different case in November. It's deep, man. Help, Dave, help.
All right. We got Zach.
Well, Zach, you with us, buddy?
Yes, I am.
Was that a good short version of your story?
Yep. That kind of wrapped everything up.
All right, so Zach, there are a couple of ways to do this, I think. Caveat here again, this is not my specialty, and there are lawyers out there who do this day in and day out. They could probably answer this in 30 seconds. But I'll tell you what my impression is. You've got a couple of different avenues. One of them is, obviously, you're trying to work with the Family Support Registry Office to get this resolved. They're the ones who are trying to enforce the order. They're the ones asking you to, pay back this money. They're the ones who are garnishing the wage. They're the ones doing all of this. See if they can unwind it. Explain your position. As I think you have. You've shown them the court order. I believe you've pulled the transcripts from the actual court hearing. That's a great move. And that way they can see and make their job easy, highlight the relevant parts of the transcript where these things that were discussed and the judge made findings on the record that may not have then made it into the actual order, but they were on the record at least, and you can see the judge's intent there, and see if the FSR will then kind of unwind what they've been doing. If that doesn't work, get in front of the judge again, and you can file a motion to have your case back on the docket, explain the situation to the judge, and again, provide these attachments in from the FSR, what they're doing to garnish the wages, the driver's license suspension, all of those different things, so that those are, maybe can even be attachments to your motion to get in front of the judge, but they were entered in court, and the judge, it sounds like the judge is being very reasonable here. I'm sure we'll just look at it and say, hey, I think there was just an error in the way that my order is being interpreted, or I need to retroactively put this in place and try to unwind these things. So those are the two avenues I would go down. Deal with the FSR, see if they'll just take care of it unilaterally. That doesn't work, get back in front of the judge.
Now, what about after, let's say he gets everything settled and they finally work it all out? Does he have any recourse afterwards? I mean, because I didn't realize that they've suspended your license too. Is that right, Zach?
Yes, they did.
Part of this whole thing. So they suspended his license, garnishing his paycheck. They say now he owes $5,800, but the reality, the original judgment gave him a payment from her for about $28,000. That's what he waived. I mean, he could have held her over the barrel and shouldered the world, but he's doing the right thing. And then, so is there anything after this to I mean, it's borderline harassment right now.
And I mean, you have to, that's another, I guess you could take that route. I'm not sure that you want the agony of...
Do it. I'm going to represent you, Zach. I'm not a lawyer, but I hang out with one once a month.
And boy, is he charming.
So
I don't know that it's worth your time to do. If they get your license back, I mean, if you have any damages because of this, if your life has been changed and you can show in a monetary way the impact it's had on you because of the aggravation of this, the suspended license, yes. But I honestly think your main focus needs to be on just trying to fix it and move on. But
it seems like he's doing the right thing. He's had contact as of Friday and Monday. He's been sending stuff. So do you think eventually this is going to get fixed?
Yeah. I feel like we're kind of right in between him making some of the right decisions on this and then getting the right resolution.
Now, is it hurting you financially not having a license and having your wage garnished? I
I mean, they're not taking that much from the garnishment.
Uh-huh.
The driver's license thing is, is a big deal.
Sure.
Getting to and from work, and then you're not having that, and everything else, and then it could impact not my current employment, but further on, just a lot of the requirements for my job. I do have to have a state license.
Yeah, Zach, when did they suspend your license?
That was a couple months ago.
Okay. Yeah, I'm glad you're getting on this now. Try to get this thing.
And he was just trying to do the right thing. That's the worst thing about this whole story. He's just trying to be cool, man. So I think that's the lesson we learned. Don't be nice.
Yeah.
Ross learned that a long time ago.
Don't be nice, right? Be a jerk. Maybe you'll be president.
I'm not saying anything.
Please, Zach's laughing. All right, buddy. Hey, man, wish you good luck on this front, man. Let us know if it gets patched up, all right?
No problem. I appreciate it.
All right, man. Green Day even wrote a song. Nice Guys Finish Last. It's true.
Oh, speaking of bands, I'm going to go see the Rolling Stones tomorrow night.
Are you really?
I'm the coolest man I know. Have you heard of these guys?
You going to flash Mick Jagger?
I'm gonna wear a leather jacket to this concert tomorrow. I saw Taylor Swift last year, and I was I'm not making fun of people, but clearly people got.
You mean Travis Kelce's girlfriend? You saw her?
I saw her live, and I saw a lot of women dressed up for this in Taylor Swift themed from the eras.
Yeah, they call them. They're called Swiffers.
I don't think they're called Swiffers.
They're called Swiffers. They're fans of her. They're Swiffers. Yep. Trust me, I know. I'm a huge Travis Kelce fan.
Okay, they're Swifties, not Swiffers.
Swiffers. Swifties
okay.
is the thing you use to clean your floor with, dummy.
I know what a Swiffer is.
Thank you for listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM, presented by McDivitt Law Firm.